Good evening. My name is Rebecca Riley, and on behalf of the Board of Student Advisors and Dean Kagan, I would like to welcome you all to the final argument of the Ames Moot Court Upper Round competition. The case before the court tonight, Michelle Jones versus Harlan Oakes and Clara Brooks, was written by Sean Spencer, a lecturer on law for the first-year lawyering program. The case presents questions about the constitutionality of a statute that authorizes a Choose Life license plate in the state of Ames. Petitioner Michelle Jones is represented by the Paul Wellstone Memorial Team, which is composed of Sarah Baumgartel, Josh Kellner, Anna Lumelski, Chris Mansour, Nels Peterson, and Rob Valivas. Josh Kellner and Chris Mansour will be making the oral arguments on behalf of the team. The respondents are represented by the John Rawls Memorial Team. The team members are Will Edwards, Aaron Katz, Scott Michaelman, Elizabeth Oyer, Chris Bastilli, and Jeffrey Wyatt. Aaron Katz and Elizabeth Oyer will be making the oral arguments for the respondents. Douglas H. Ginsburg, the Chief Judge of the United States Court of Appeals for the District of Columbia Circuit, will be Chief Justice for this evening's argument. He will be joined by the Honorable Fortunato Benevides of the United States Court of Appeals for the Fifth Circuit and Judge Karen Nelson Moore of the United States Court of Appeals for the Sixth Circuit. Please hold your applause until all oralists have finished speaking, and remember that the petitioner will be making rebuttal arguments. You will have the opportunity to take pictures when the judges first come in. They will stand for you at the front for a few minutes so everyone can take pictures. After that, the only person allowed to take pictures will be the law school photographer. Also, we ask that you all please turn off cell phones and pagers at this time. Best of luck to both teams, and enjoy the argument.
Clerk will call the case. It's Jones against Oakes and Brooks, number 3-1175. You are Mr. Kellner?
Yes, Your Honor.
Please begin.
Thank you. Mr. Chief Justice, may it please the Court. My name is Joshua Kellner, and I will argue that plaintiff Michelle Jones has standing to contest the constitutionality of the Choose Life License Plate Act of 2003. My colleague, Christopher Mansour, will argue that the act violates the First Amendment. Your Honors, in this case, Michelle Jones alleges two separate and distinct injuries in fact, each of which is in itself sufficient to establish standing. First, Your Honors, Ms. Jones was disadvantaged by the government's discriminatory operation of a speech forum. While those in the state of Ames who wish to obtain a pro-life license plate may freely do so, those who wish to obtain an analogous pro-choice plate may not. As this Court has repeatedly affirmed in the First Amendment and equal protection context alike, where the government has a constitutionally imposed duty to maintain neutrality among parties similarly situated, and it breaches that duty, one disadvantaged by that breach has standing to proceed in court.
Could you tell us what is the practical disadvantage that she's under? What's the injury that you're describing as a disadvantage?
The injury that we're describing as the disadvantage here, Your Honor, is that while those who hold one viewpoint are able to express their views in the license plate forum, those who hold another viewpoint, that is the pro-choice viewpoint, cannot.
Well, how is Ms. Jones any worse off than she was before this statute and program were instituted?
The reason that she is worse off, Your Honor, is because the government has chosen to admit her content matter to the forum. That is, it has decided, in effect, that the content of abortion is in bounds for license plates. However, based solely on the viewpoint that she holds, it has barred her viewpoint from the forum. This court has repeatedly...
I understand that, but I'm trying to understand it from not as a sort of legal doctrinal matter, but when she goes home at night, how is she worse off than she was before?
The reason she's worse off, Your Honor, than she was before is because, as noted in the record, she feels imposed upon and excluded.
So it's bad feelings.
Excuse me, Your Honor?
Bad feelings are the injury?
It's not just bad feelings, Your Honor. It's bad feelings going to a breach of a government duty of neutrality. This court has repeatedly noted, for instance, in the First Amendment context, and here I would draw the court's attention to Arkansas Writers Project v. Ragland, that where the government has a First Amendment duty of neutrality and it breaches it, that one who is disadvantaged has standing to proceed in court.
What was the disadvantage in that case?
In that case, Your Honor, the disadvantage was the fact that the government was giving a First Amendment benefit to one side, that is, people who published religious publications, but not to those who did not.
It was a tax case, wasn't it?
Well, that was a tax case, Your Honor.
Right, so there's no tax here. There's a palpable burden with a tax.
But this
Here
court
you've
has...
got some bad feelings. This is not the court of bad feelings.
When did she sustain the injury? In the tax case, the court was clear to point out that at the very time that tax was paid, the injury occurred. When did this injury occur?
This injury occurred, Your Honor, when the government created an imbalance. It's important to note...
Now, the time, and when was that?
The government created the imbalance when it enacted the Choose Life Act. And
No, just so the passage of the act itself created her injury?
it did, Your Honor.
So that was even before before they even had the 300 signatures. She was already injured.
Yes, Your Honor. And the reason for that is because, as this court has repeatedly noted, the problem is the disadvantage. While the people...
Is the disadvantage in the use of license plates that say Choose Life?
In the first instance, Your Honor, it's the opportunity even to obtain the license plate. Now, the 5,000 citizens in the state of Ames who wanted a pro-life plate had the opportunity to get up to that 300-person threshold. Those who were pro-choice did not.
This particular act does not prohibit or have any prohibition with respect to her request. How does, and your attack is on this act itself, how does this act harm her?
Your Honor, as this court noted in Heckler v. Matthews, where the injury is the disadvantage, the injury can be remedied by actually striking down the disadvantage, that is, leveling the playing field. It's important to note that this court has never required that an injury, in fact, be something a plaintiff can hold in the palm of her hand. As Judge Bork noted, writing for the District of Columbia Circuit Court of Appeals, the loss of First Amendment freedoms, even for a small period of time, constitutes irreparable injury.
You know,
Can't she speak,
okay.
though? Can't she speak? How has she lost her First Amendment freedoms?
The reason that she lost her First Amendment freedoms, Your Honor, is because the First Amendment imposes a duty upon the government, that is, to treat similarly situated parties in the same way. The important thing to note is that this court has always had a strong policy justification against insulating under-inclusive statutes from constitutional challenge. While the extension of a benefit to one side may not bar a plaintiff from obtaining the benefit later on, it still creates a disadvantage, and it still does breach the government's duty.
That there may be nobody withstanding to challenge a particular statute is a matter of interest, but it's by no means dispositive that anyone does have standing.
It's certainly by no means dispositive that anyone does have standing, Your Honor, but in this case, we strongly believe that Ms. Jones does. In fact, for their parts, respondents do not contest the general idea that when the government has a duty to maintain neutrality and breaches it, that an injury in fact may result. Their point only is that plaintiff had to undertake what they say was a minimal step in order to gain access to the forum. However, it is unclear what they expected when they said a minimal step.
Why shouldn't she have to seek to get pro-choice license plates allowed?
The point, Your Honor, I think, is that the legislature can require her to go through an application process. But where the legislature pointedly refuses to do so, a plaintiff should not have to grasp at straws nor read the legislature's mind. In this case, we know that on the face of the statute, there was no application procedure she could have used. Moreover, we know that while there were posters posted in DMVs advertising the existence of a program, so far as we know on the face of this record, there was nothing that says, and if you don't like the options are available, please tell your local legislature. There is no indication on this record that the legislature contemplated any nexus at all between whatever petitioning the legislature entailed and the scheme itself. Now, the point that respondents...
Let me ask you, how is her situation any different from that of, say, somebody who's unsatisfied with the selection of books that the library, public library, has purchased and made available? Maybe an author whose book wasn't purchased. Would that person be standing to complain about that? Let me put it another way. Is there a constitutional injury there?
I don't believe that there would be, Your Honor. But
how is it any different?
The author wouldn't have a First Amendment right, I imagine, to have the library stock the book.
Well, do you say there's a First Amendment right here for Mrs. Jones to have her slogan on a license plate? What's the difference?
The difference, Your Honor, is that where the government is administering a speech forum, it has a duty to maintain this generally applicable idea of neutrality.
Libraries have something to do with speech.
They have something to do with speech, Your Honor, but at the same time, the government is not constitutionally required to admit certain books to the library. It's not a forum, and the government can make the choices that it wishes to make.
Can't the government make its own choices? For instance, your argument would seem to suggest that if the legislature in Ames decided that one of the permissible tags would have stamp out fascism, that a petitioner could claim that she would have the right to have a license plate that says Hitler was misjudged because her own view is that Hitler has been misjudged by society, and she's not getting her right to advance her position, her idea in the marketplace of ideas.
Well, I think, Your Honor, that goes to the merits of the issue. And I imagine that my colleague, Mr. Mansour, could speak to it far more eloquently than I. But the general point is that no one in this case contests that when the government is operating a speech forum, they have to maintain viewpoint neutrality. And respondents, for their part, only argue that this was not a forum because the government was doing the speaking. In any event, another important point to note is that even to the extent that plaintiff could have undertaken this application process, it would plainly be futile.
But there isn't an application process, right?
Right, Your Honor.
So let's go on to something else.
Okay. Another thing that we then might go on to is Ms. Jones' separate and distinct injury, in fact, and that is what we call her Lakewood injury. As this court found in Lakewood v. Plain Dealer, where one is made subject to a licensing scheme that subjects somebody to unbridled discretion on the part of a licensing official, that person has suffered an injury in fact and may proceed to court.
Should that doctrine apply to legislatures? That was a case involving the mayor of Lakewood.
It should apply to legislatures, Your Honor. And in fact, this court...
Aren't legislatures fundamentally different from mayors or other administrative bodies?
They're different in certain ways, to be sure, but not in the important ones. The concern that the Lakewood court evinced was the danger of censorship. That is, that when there are no generally applicable standards to cabin a licensing official's discretion, it can engage in viewpoint discrimination.
Do we have that situation here? It seems like we do have standards. The legislature has picked out certain things that will be allowed, told the commissioner that if there's 300 applicants that they shall issue the license. How is this the same as a situation in which there are absolutely no standards and it's completely at the whim of an administrator or mayor or something to decide, who gets a license and who doesn't get a license?
Well, it doesn't in the important ways differ from that situation, Your Honor. In this case, the licensing decision at issue is whether to admit content into the forum. The legislature has never told people in Ames why it rejected a pro-choice plate, which it did in January of 2003.
Well, you're treating it as though there were an application, which as we established, there wasn't. In the newspaper case, or the mayor's case, the court was concerned with self-censorship and chilling effect and all of that, because you had a newspaper that wasn't going to be able to distribute except at the permission, the grace of the mayor. And so we were concerned with the chilling effect on the newspaper, trying to appease the mayor and so on. I don't see how that carries over to the situation of Mrs. Jones, who what's she going to do, decline to drive?
Well, it's not...
Be intimidated about driving because she can't have the slogan on her car?
It's not declining to drive, Your Honor. The fact that she might engage in self-censorship would go to whether she'd be willing to criticize the legislature. She knows in this case...
Because they might not give her the license plate she wants?
Not only might they not...
Once they've not given it, I should think she'd criticize them vociferously. She's suing about it, for goodness sake.
The Lakewood Court was also, though, concerned with the acts of parties who were already given licenses. Their concern was that one who had a license but didn't know why the licensing official might take it away would engage in self-censorship. Basically, they want to stay on the legislature's good side.
So the concern here is that the pro-choice people who want the license plates with that pro-choice slogan are going to be intimidated or are going to suck up to the legislator? Is that it?
It's both of those, Your Honor, and this is the undercurrent of the Lakewood opinion.
Is there a more plausible suggestion?
Well, I think that maybe something which to some extent supplements our case is the fact that the court addressed an analogous situation in Shuttlesworth v. Birmingham. There it said that a municipal legislature was also subject to this general network of concerns. That is, that it had to have generally applicable standards to cabinet's discretion.
Oh, I agree with you. There's no difference between the mayor and the legislature. The question is whether there's any difference here between a newspaper and a person who wants a slogan on their license plate.
The Lakewood Court, however, was not concerned merely with confining its holding to newspapers. The point was people who might exercise their First Amendment rights. And the idea here is that while the individual is not publishing her views for commercial purposes, she still has the right to criticize her government, which to some extent is the lifeblood of a democracy.
And what can they do to her? What can they do to her that she's going to be chilled by?
What they can do, Your Honor, is they can either, first off, refuse to give her her license plate, as they've already done.
They've already done that. That's what creates the issue. Now the question is, why is that going to be intimidating, or a scheme like that to be intimidating?
It's also intimidating to people who have the license plate already.
They come take them away?
They can, Your Honor, and there are no standards that the legislature has to use to tell the court this is why we're doing it, and we're not discriminating based on viewpoint.
Let me ask you a variation on the question Judge Benevides put, but I think, I'm not so sure it's a merits question. That's why I'm asking you. The appellee in this case says that the approach that you're proposing would require the government to, not just to make available opposing pro-choice and what's the other, anti-choice slogans, but a whole range of viewpoints, right? To say, well, we've got to anticipate every stripe here and make available license plates just for every taste. I remember seeing in this same Commonwealth not many years ago a bumper sticker that said, "Nuke the unborn gay whales." Now, you know, what's the legislature going to do with that?
I see my time is up. May I answer?
Well, yeah, please.
Thank you. Well, I don't know much about the whales,
No,
but I think a more general and case-specific point to make is that to the extent this is any dilemma at all, it is of the legislature's own choosing. If they were worried about being able accurately to discern the range of viewpoints their citizens hold, they should actually make a meaningful effort to ask them. The legislature should not, on the one hand, be able to close the process to accountability and to applications, and then, on the other hand, to talk out of the other side of their mouth and say, well, how could we ever have known what people thought? They should have to ask. Thank you.
Further questions? No? Thank you, Mr. Kellner.
May it please the Court. My name is Christopher Mansour, and I will argue that the state of Ames violated Michelle Jones' First Amendment rights when it opened its license plates as a forum for private speech on the subject of abortion, but then excluded Ms. Jones' pro-choice views from that forum. This Court has consistently emphasized that when the government discriminates among private speakers, based on the viewpoints they seek to express, it strikes at the very heart of the freedoms that the First Amendment guarantees. As the court wrote in the case Red Lion, it is the very purpose of the First Amendment to preserve an uninhibited marketplace of ideas so that truth may ultimately prevail. But in this case, the state of Ames is distorting that marketplace by opening a forum and then allowing only its own preferred view into that forum. Now, respondents do not contest that the state has sought to favor one viewpoint over another here. Rather, they suggest that that governmental favoritism is acceptable under the Constitution because the government is merely expressing its own view. But neither of the...
Do you doubt that the government is expressing its own view in the state of Ames?
We do doubt that, Your Honor. We also consider it somewhat irrelevant to the case, but we do doubt it.
Doesn't the Act say specifically that the state prefers adoption over abortion?
There's no question that the state prefers adoption over abortion. And the Act does say in its stated purpose that the purpose is to further that goal. But the question is, how does it do that? The way that it does that is by allowing private citizens in the state of Ames to express their views, so that when citizens drive down the highway, they can see all of their private citizens, all of their fellow citizens who have chosen to support this pro-life view. But the state has not offered a similar opportunity to pro-choice citizens.
Well, it does. It's favoring one choice, but it is one of the choices is to have a baby, and they're preferring that choice. It's not like the choice is to go either way, isn't it? It's not necessarily saying not to choose abortion or outlawing that. It's making its policy determination as an elected body that it prefers a birth, and it prefers providing money so that pregnant women will have the children, and that they'll be able to be counseled and provide homes for these children.
Well, there's no question that the state is entitled to choose its own view on the subject of abortion and to express that view to its citizens. But what it can't do, what this court has always forbidden the government from doing, is setting up a forum for private speech and then discriminating among private speakers based on the viewpoint that they are trying to express.
Could the state of Ames make bumper stickers and only give out to the citizens bumper stickers that say pro-life or pro-adoption?
That would be a much different case, Your Honor.
Why is it different?
Well, where the state merely prints its own literature, it may print pamphlets, handbills, anything, and distributes them to citizens, there's no government program there. The citizens may choose to...
It's merely printing, using your argument, it's merely printing the license plates that say pro-life.
I'm sorry. The license plates, however, remain on, they continue to be government property. It's a continuing government program. The government has opened up its own property so that private citizens can use that property to express their own views. Now, if the government had a...
That seems to be, in part, the issue, whether it has, right?
It is.
And I'm not sure by what lights we're to determine that when the state says it wants to publicize certain views of its own, that it has opened up a forum for everyone to participate, rather than simply, as in the case of publishing its literature, not opening a forum, but speaking its mind.
Well, this court's inquiry has always been into whether a government-created program contains a significant or facilitates a significant amount of private speech. And that's true even when there's also an aspect of government communication in a program. And two cases that show that most clearly are Woolley and Forbes. In Woolley, this court considered the constitutionality of a state rule that required citizens to display the state motto on their license plates. The court noted first that the state was engaging in communication, was expressing its own view by having that requirement. But the court also found a private speech interest in that case, the interest there in being free from compelled speech. The private interest in that case controlled, and the state couldn't simply claim that it was only trying to express its own message.
But the interest was, I think, as you just said, being free from compelled speech, right? Not
Yes.
having to say something you don't believe at the behest of the state.
No, it was a different private speech interest. The private speech interest in this case, though, is no less important. It's the interest in being free from government discrimination based on the viewpoint of one's private speech.
A learned professor at Harvard at dinner time was wondering about a stamp. If we have a stamp that says drink milk, are the vegans have access to force the United States government to have a stamp that says milk, don't eat the product of animals?
I don't think so, Your Honor. First, it's certainly not clear that most people even understand themselves to be communicating any message based on the stamp they choose. Some people may merely like the decoration or grab the closest stamp at hand.
You don't think there's
about that.
expression in those stamps?
Even if there is, Your Honor, it's,
Picture of Martin Luther King? You don't see the Grand Wizard of the Ku Klux Klan?
no, there certainly is government expression. The government is certainly expressing its favored views and the positions that it supports.
So is
on
it
the
opening
stamps.
up a forum?
No, Your Honor, it's not. The purpose of the program and the structure of the way the program of issuing stamps operates gives no indication that it's designed in order to facilitate private speech. Here, on the contrary,
But I thought the whole reason that for the proliferation of stamps was to appeal to different niche audiences so they could communicate their message by the stamp they choose.
well, I don't think that they necessarily use the stamps to communicate their own message. They may prefer to use that stamp, but for example, someone who prefers a Martin Luther King stamp may use that same stamp to pay their bills, to send off something that they don't care what the recipient understands them to be communicating based on the stamp. In any case,
But the New Hampshire case was one of compelled speech. So I'm not sure what it contributes to your argument.
what it contributes, Your Honor, is that it suggests that even where the government is trying to communicate its own message, where there's also a private speech interest at stake, that private speech interest remains protected by the First Amendment. Forbes demonstrates this perhaps even more clearly. Forbes concerned the ability of a public television station to exclude fringe candidates who had no chance of being elected, from a televised debate. In that case, the court noted first that public television stations are engaging in communication, are engaging in speech when they make their programming decisions. But it held, nevertheless, that where the state operates a program that involves private speech, as where it hosts a candidate debate, it must treat the candidates in a viewpoint-neutral way, because it is open to forum. The same is true here. Ms. Jones simply asks to be treated in a viewpoint-neutral way.
Why is this, I'm sorry. Go ahead. Why is this private speech? Didn't I assume that Ames is like the rest of the other 50 states, and that the process, the presenting of a bill is public record, and that you have debate, and that the people that were against this message had input into the political process, and that ultimately the statute in question was passed by the legislature? Why isn't this different from the secretive situation, unstandard, undisciplined, arbitrary portrayal that you have presented here?
Well, we don't seek to portray the process as being secretive necessarily. The issue of secrecy doesn't really go to the question of private speech. The reason that it's private speech is because it permits private speakers to choose which viewpoint they wish to express, and it allows them to control the content of the message they express. And reasonable observers looking at these plates on the highway would certainly understand that if they see a Choose Life plate on someone's car, they would naturally understand that that person is communicating their support of that view. And respondents indeed don't contest this. They concede that there's private speech in this case. They argue,
Is it relevant that in some states the Choose Life bill has been vetoed by certain governors, and then when new governors have come in, the bill which has passed the legislature has then been approved by the governor, so that essentially the vagaries of who's in power will result in whether the slogan of the state that people can put on their license is Choose Life or pro-choice?
I don't think so, Your Honor. There's no question that the state has chosen to endorse the Choose Life message over the pro-choice message. That's exactly the constitutional violation that Ms. Jones seeks to contest. No one doubts that. But there's no actual act of communication in this case until a license plate actually appears on a car. It cannot be the case that every government statute enacting a given policy is deemed an act of government communication and hence immune from scrutiny, because every statute in a sense, communicates the legislature's approval or disapproval of the policy contained. The act of communication in this case is when a private citizen chooses to place a license plate on his or her car. If it weren't for the volition of private citizens, the state could enact this program, it would go on the books, but no communication would take place under it. That's the reason that it must be understood as setting up a forum for the communication of private views.
So this is in your brief. You say only where the private individual has virtually no editorial control can the government speech doctrine apply. In other words, in every other case, there is this element of private speech and different obligations attach. What is the element of editorial control here?
The element of editorial control has to be understood with reference to, as I was saying, the fact that the communicative acts in this case is the placing of a license plate on a car. That's when the communication takes place.
But editorial control implies that the person putting on the license plate has some discretion, right?
Yes, and citizens do. They can choose to place no message at all, or they can choose from any of the license plates approved by the state. Now, it's certainly true that the state...
They can choose from a fairly constrained list, what is it, 46, I think, options that they have ranging, and I'm not sure they all do because they can't all put on their naval officer if they're not a naval officer. So how many does an ordinary civilian have?
30-something, Your Honor.
30-something, all right. So there are 30 slogans that you can put on there. Save the sea turtles, I think, is one.
Yes.
And the one in suit here and a few other things like this. So or nothing. And that's the extent of the editorial control that's at issue, right?
Yes, but the court held in Forbes, citing an earlier case, Hurley, that an act of communication is no less an act of communication merely because one chooses to pass along speech originally crafted by someone else. So when a government television station, as in Forbes, rebroadcasts a program that was created by someone else, that's no less a speech act because it wasn't the original author of the content. And that's true here.
Your opponent has argued for a four-part test. What part of the four-part test do you disagree with, or what part would you add to it?
In actuality, we don't disagree with any of the prongs so long as they're understood not as lower courts have applied them in a sort of haphazard way, but through the lens of this court's precedent. The question must always be not whether an entire program should arbitrarily be classified as government or private speech, but whether a significant private speech component is present in a given program, because if it is, then the First Amendment requires that it must be protected. So, for example,
and how do you define significant? Is it 10% private speech?
We don't suggest any specific definition. We use the word significant only to imply that where a speech interest is insignificant, as for example in the case of postage stamps, it need not concern this court, almost by definition. Something that's insignificant need not trouble the Supreme Court.
But how do you decide that postage stamps, the speech is insignificant, the private speech is insignificant as compared to license plates? I mean, is this something that you decide or we decide, or?
Well, we certainly would leave it to your discretion.
Are there standards for us to narrow our discretion, standards?
I think to some extent it's a question of applying common sense, and when citizens use license plates, choose to put these specialty plates on their cars, it stands to reason that other citizens would understand them to be conveying a message. Cars are a typical place of self-expression. People put bumper stickers on their cars. They have vanity license plates where they can affect the letters and numbers. And these are understood universally as ways that people can communicate their associations or messages. I don't think that the same is true with postage stamps. To the extent that the government does have other programs that encourage people to engage in acts of private speech, as this court has always held, where the government opens a forum, whether it's a public or non-public forum, the government must act in a viewpoint-neutral way. And that's nothing new that we suggest under this court's precedent.
Your claim is that the forum is the license plate, right? It's not the vehicle.
Yes, the forum is the license plate and the license plate program.
In the New Hampshire case, it was a sticker that went on the windshield, I think. Here is the license plate. So Mrs. Jones is quite at liberty to put a bumper sticker on, right, that puts out her point of view, or that says, don't believe this license plate if she happens to be using one of the pro-life ones. Right? So I'm not sure how she's injured here. Not injured, we went over that. how the state is excluding her views from the forum, because if you define the forum narrowly enough, you can always say something is excluded. The forum could be this microphone rather than the bench.
The question, Your Honor, though, is whether her view is being excluded based on its viewpoint. And the court is consistently...
Well, no, it still has to be excluded from something, right? So what's the something? Why is it a license plate?
I see that my time is up, man.
Well, I'm interested in your answer, though.
Sure.
What do you have to say? You said something about the program, actually.
Right, and the court has always held that the mere existence of other, even other easy avenues of communication by which someone could express a message doesn't change the fact that when the government runs a program, it has to do so in a viewpoint-neutral way. Thank you. We'll reserve 5 minutes for rebuttal.
Thank you, Mr. Munzer. Mr. Katz.
Mr. Chief Justice, and may it please the court, I will be addressing the issue of standing. My co-counsel will be addressing the government speech issue. On January 31st, 2003, the Ames legislature passed the Choose Life License Plate Act, which approved the creation of a specialty license plate containing the words Choose Life.
I think you should assume we're familiar with the background.
Okay. In the interim between the period of the CLLPA's passage and Ms. Jones's filing of her claim in federal court, she did not notify any Ames official of her desire that the Ames legislature pass a bill creating a pro-choice license plate.
Was there not a bill introduced that would be a pro-choice bill that was rejected by the one house of the legislature?
Justice Moore, sometime during the month of January, there was a bill that would have approved the creation of such a plate. The record doesn't show the text of that bill. We don't know exactly why it was not passed. It could have been for a reason that's viewpoint neutral. For example, the legislature could have disapproved of the use of the plate revenue, where those funds went. On a Rule 56 motion, it is Ms. Jones's burden to introduce these facts in the record. If she's going to use the fact that that bill was not passed as evidence that it would be futile for her to apply to the speech forum, she bears some burden to show why it would be futile.
I don't know how we could know whatever one could plausibly find in the legislative record. I don't know how the court could make a judgment about why a bill was rejected. I mean, unless you have a majority standing up and saying individually, each member, giving the same reason, I don't see how it would be possible for us to say.
Well, Mr. Chief
It's hard enough to know why a bill is passed, let alone rejected.
Well, Mr. Chief Justice, I think that if we knew the text of the bill, we could start making some guesses. But the circuit courts that have...
We know from the CLLPA that the legislature said that it approves adoption as against abortion. So don't we have a pretty clear indication that the reason why the legislature didn't pass the pro-choice license plate bill was because of the substance of the contents?
Justice Moore, the viewpoint of choose life is not totally inconsistent with the viewpoint that Roe versus Wade was correctly decided, and that someone has a right to an abortion. Many people hold this viewpoint. She does not argue, however, that the reason that this plate was passed was because of viewpoint discrimination. She claims that this is evidence that it would be futile for her to apply to the forum. I think it would be helpful to go to a more garden variety forum, such as a parade or, Mr. Chief Justice mentioned, a library. If we can assume that a library is a forum and Ames decides to start a library, it builds the library. It's buying books to fill the library. And it buys the Federalist Papers. And the librarian has decided not to order an issue of the Communist Manifesto. The very fact that they ordered the Federalist Papers book does not show that they are discriminating, in other words, abridging the free speech rights of people who have a communist viewpoint and want a Communist Manifesto book. If it is a forum, a person that wanted the book in order to show that they have been the victim of viewpoint discrimination would have to make some attempt to ask the legislature that they want their viewpoint to enter the forum. At that point, the legislature or the librarian or whomever, if they rejected that request, they could bring a viewpoint discrimination claim. The requirement that someone seek access to a forum is not some administrative or statutory requirement. It's a prerequisite step to showing that the government has abridged one's free speech rights.
Wouldn't you say it's an exhaustion idea?
Well, Mr. Chief Justice, I don't think that this is an exhaustion idea.
Why?
The First Amendment does not require the state to facilitate anybody's speech. Going to another garden variety example form of a parade, let's say there's two competing groups.
I thought you were saying that she had to go to the legislature and sort of exhaust that avenue of political relief before she could say that she was in any way injured.
Well, Mr. Chief Justice, it's not that it's an exhaustion requirement. She would have to go to the legislature, make some attempt, in other words, do something as opposed to nothing, to let them know that she desired the creation of a pro-choice plate, in order to show that the fact that they have not passed a pro-choice plate was somehow violating her First Amendment rights. The First Amendment...
Well, we know they didn't pass such a bill, and that they looked at one and didn't pass it. So where's the doubt? Is the doubt that she was concerned about it? I mean, we know that too, I think.
The doubt, Mr. Chief Justice, is that on a scarcely more than sparse record, this court would simply be guessing at the reason why that bill was not passed. The circuit courts would have come up with they call it a futility exception to attempting to access a government benefit. And in this case, the benefit is the form itself. Those cases have held that the plaintiff must make a substantial showing that applying for the benefit would be futile.
Well, why wouldn't it? The state has announced it in the caption of the statute that they want to promote and that they're in favor of people just making the choice to have a child. Now, if that's their announced basis for passing the statute, because that's what they prefer, why would we think that she would apply and that they would approve something that's the opposite of what they've just told us as a collective body that they prefer?
Justice Benevides, if this is a form, and again, we're arguing that, of course, it's not a form. If it is, it's a rather strange-looking form. But if it is a form, this court would be asked to speculate, to guess, to presume that the Ames legislature would act unconstitutionally if somebody asked to access that form.
Assume that she did seek the legislature to give her the kind of plate that she wants. Would she then have standing?
Justice Moore, if she did do something as opposed to nothing and went to the legislature and made clear her view that she desired the creation of a pro-choice plate, because that's her viewpoint, and they ignored her or did nothing or came out with a statement saying, forget it, get out of here, she would have standing to challenge it. Now, that's not to say that she would have standing to challenge the CLLPA. The CLLPA is not refusing or excluding her from this form at all. The CLLPA it's not the benefit here. The benefit here is the form itself. And the CLLPA does nothing to exclude any particular viewpoint or person from that form.
So what could she challenge?
Well, in this case, I think it's clear from the brief that she says that the problem is that 79.4, I'm referring to the statute that creates the very concept of a specialty plate, that statute is defective because it does not have a formal application process. In other words, that the Division of Motor Vehicles has no discretion to approve a plate or to issue a plate that is not on the exhaustive list that the Ames legislature itself has created. On page 35 of her brief, her initial brief, for instance, in footnote 11, she offers this court a very succinct argument that the real problem here is that the Ames legislature has to divest itself of what they might term gatekeeping authority over this form and give the Division of Motor Vehicles the ability to approve the creation of plates. I think it's odd that in the very last thing that she says in her initial brief, she gives this court a legal standard, a legal rule that it could come up with, that 79.4 is defective, and yet she hasn't chosen to challenge Section 79.4. She's chosen only to challenge the CLLPA because, as she terms it, it gives a license plate to her ideological adversaries. There is no contention that the CLLPA causes or embodies the unbridled discretion that the legislature has over the exhaustive list of Section 20-79.4.
Well, she's made two types of injuries claims, right? One is that she's subjected to this unbridled discretion that I suppose, by your argument, would be traceable to the general program, to 79.4. But the other is that the passage of the CLLPA injures her in disadvantaging her in a public debate she's having with other people about this issue.
Well, Mr. Chief Justice, in, for instance, Gladstone Realtors, and several times since then, this court has said that for Article III purposes, a relevant injury is one that results as a result of the defendant's illegal conduct. In this case, the injury of disadvantage could only be a relevant Article III injury if it was the result of a violation of Jones's First Amendment rights. Now here, the disadvantage comes from the fact that Jones hasn't asked to enter the forum, and other people have. So if we can go to the parade example, and there's two competing groups, and one decides to apply for a license to march in the parade, and they are granted their license and they march, and the competing group decides not to apply for a license at all, and they're sitting at home, and they're watching their ideological adversaries marching and speaking. In some very real way, they're disadvantaged, but this disadvantage is not a relevant Article III injury because it's not the result of illegal conduct. It's not illegal to issue a license.
That's a merits question, isn't it?
Well, Mr. Chief Justice, I think it's odd. The injury in fact requirement does sort of collapse into a sort of merits inquiry. This court noted in Lewis versus Casey that the injury in fact requirement often looks like a merits question. Indeed, 3 concurs noted that it looked very much like a merits question there, but nevertheless the majority was correct in characterizing it as an injury in fact requirement. The injury in fact requirement itself, because it must be the result of illegal conduct, is a merits inquiry, and necessarily so.
Well, it has to be the result of conduct that is alleged to be illegal. Whether it's illegal won't be resolved unless the person has standing and we get to the merits. Right? But if there's an allegation that this was unlawful, the focus of our inquiry is whether there's an injury, of the preliminary inquiry. Right? That's all, whether there's an injury, not whether it's unlawful.
Well, Mr. Chief Justice, on a Rule 56 motion, the facts alleged, the facts that the plaintiff presents on the record, have to at least be enough to raise a question of whether this is a violation of law. In Lewis versus Casey, the allegation was that a prison violated a prisoner's rights because they didn't provide a decent library. The prisoner was not going through habeas corpus proceedings. Indeed, there was no claim that he was in the midst of any court proceedings whatsoever. And Justice Scalia said that this would be an injury in fact if the Constitution required that a prison give every prisoner, no matter if they were going through court proceedings or not, an adequate library. Justice Scalia said that the First Amendment doesn't require that. And that was even so even though there were no express holdings on that point. It was, in other words, a semi-novel holding that a prisoner did not have a right to an adequate library, save for the fact that they're going through habeas corpus proceedings.
Well, it's a fair point because we there decided that we said that this wasn't a legally cognizable injury, essentially, right? We didn't deny that he was without the books. He was.
He certainly was.
And that puts him at a disadvantage, right?
He certainly was.
If he wants to dream up some case, but he didn't have a right to them. So it's a good point, but I'm not sure that it travels very far. Here we've got not a frivolous claim.
Well, Mr. Chief Justice, I wouldn't characterize it as a frivolous claim. I would characterize it as something at the intersection of injury in fact standing and rightness. She has not shown that her First Amendment rights have been abridged. If you look at a case like Cornelius, on page 801 of the Cornelius opinion, this court says that as an initial matter, a speaker must seek access to public or private property dedicated to public use in order to raise First Amendment concerns.
What I'm hearing from you is a constant emphasis on her not having sought relief from the legislature. If we put that point aside, you concede that she does have standing. Is that correct?
Justice Moore, I would concede that she would have established an injury in fact. If we concede that there's been viewpoint discrimination and she's been disadvantaged, yes. But the CLLPA is not the cause of that disadvantage. And
it allows for one viewpoint to be expressed, but not her viewpoint. Why does that not cause her disadvantage?
Justice Moore, the CLLPA does not exclude her from the forum or prevent the legislature from creating a pro-choice plate. The law that you have to seek to enjoin has to itself be illegal. I don't know of any case where this court or any federal court has enjoined an otherwise illegal law, even in a case such as Metropolitan Washington Airport Authority. The veto that was enjoined there was illegal. It was deemed to have violated the separation of powers.
How about the Ragland case and the taxes? Was there any injunction there? How would you deal with that?
Well, in that case, the plaintiffs were actually seeking a declaratory judgment from this court that the tax that they were made to pay, the tax that was imposed on them, was discriminatory because other First Amendment speakers, based on content, were not taxed. And the declaratory judgment would have actually allowed them to pursue their 1983 claim in state court.
So couldn't there be a declaratory judgment here that it is discriminatory on the part of the legislature to allow only one side to be heard?
Justice Moore, that would be a classic advisory opinion. She's suing to enjoin a law that has absolutely nothing to do with her ability to speak in a forum. If she were to ask this court to say that the legislature's rejection of her request to access the license plate form was unconstitutional, that would be an entirely different matter. But I think we keep going back to this.
Well, I'm not sure that I got some of that. It seems to me that the gravamen of her claim is this disparity in treatment, and that it would be redressed if the CLLPA were invalid, because then the state wouldn't be favoring anybody. It's true she wouldn't be able to get her message across, but neither would her adversaries.
Well, Mr. Chief Justice, she still would be disadvantaged to the extent that other people would have the ability to speak on license plates about all sorts of things, sea turtles,
She's not
wildlife.
complaining about that.
Her disadvantage goes away. If the statute is enjoined or ruled unconstitutional, her disadvantage, that is, not having to compete with the license, is gone, isn't it?
Justice Benevides, I think if this court allowed her to seek to enjoin only one particular statute, a statute that doesn't prohibit her from accessing a forum, this court would be allowing nothing more than someone to bring a claim for an injunction that functions much like a civilized version of a heckler's veto. Here, she keeps coming back.
But wouldn't the message be to the legislature to open up the forum to both sides or all sides if it's a multi-sided issue?
Justice Moore, she does say this at page 5 of her reply brief, for instance, that it would redress the injury because the Ames legislature would then likely enact, and she says, a scheme that accords with the plain dealer principle. Now, this would be simply an advisory opinion. Her claim here, when she rebuts the claim that she must attempt to access the forum, she continually retreats back into the position that the problem is not that she's been rejected, but rather that 79.4 is defective because it does not include an application process. Now, this sounds much like a plain dealer type injury, but even if this court were to assume, and we certainly think that this is not the case legally, but even if it were to assume that the legislature, in order to accord with the plain dealer line of cases, if they establish a forum, has to divest itself of gatekeeping authority over the forum, the correct challenge would be over 79.4, to enjoin the entire specialty plate scheme as a whole. If 79.4 were enjoined, there would be no concept of a specialty plate, there would be no specialty plate forum, and thus there would be no forum that vests unbridled discretion in the Ames legislature.
I wanted to ask you one more thing. Suppose that the state opens up a forum that is undeniably a forum, let's say a theater, and they make it available to all manner of speakers, except on one issue, they allow only the one side of an issue to speak. They say, we'll have the choose life side and not the pro-choice side. Now, somebody comes along and says, we want to put a stop to that. They shouldn't be able to do that. You say she has to sue to close down the theater rather than to get an injunction against the state in the future, presenting only one side of this issue?
Well, Mr. Chief Justice, in that case, the proper challenge would actually be to enjoin the state, to force them to allow their theater group to get on the stage and speak. It would not be to go after whatever particular theater group they don't like today and say the court should stop them from speaking. Here, I think that the problem is potentially that this court would be violating legislative immunity or some sort of separation of powers doctrine if it required the Ames legislature to pass a law creating a pro-choice plate.
We wouldn't purport to do that.
No.
Thank you, Mr.
I see my time is expired. Thank you.
Mr. Chief Justice, and may it please the Court, to accept petitioner's argument that license plates are private speech, but that stamps and government-issued bumper stickers are not, would be to adopt a totally unprincipled government speech doctrine. Ms. Jones's First Amendment challenge to the Choose Life License Plate Act is little more than an attack on a principle that this Court has continually restated, that the government may enlist private individuals to aid in transmitting the government's message. License plates, bumper stickers, and stamps are all examples of instances in which individuals affix to their own personal property or to their persons a government message in order to express their support for or their endorsement of what their government stands for.
Is there a difference in the bumper sticker example, the one that I gave earlier, of the government paying for the bumper stickers, that the government is funding the speech in that example of bumper stickers, whereas here the individuals are paying for their license plates, special amounts for the Choose Life ones?
Justice Moore, I don't believe that there is a difference in the fact that the government might fund something like a bumper sticker. In cases in which this Court has attempted to distinguish private speech from government speech, this Court has never held that who funds the speech is a relevant consideration or is determinative of who's speaking. And evidence of this is seen in the Rosenberger case, in which the government paid substantial amounts of money to facilitate private speech by student groups. The key factors in determining that that was student speech, in spite of the fact that it was funded by the government, were that the speech was to serve a purpose that was created by the students, and the content of the speech was controlled by the students.
Is a relevant factor here that the money that is earned by the sale of the Choose Life license plates, is half of it is funneled back into Choose Life types of charities, so that it is private funding of private charities?
The use of the funds from the government program support the fact that this is government speech, because it demonstrates that the program, the license plate program, is established for the governmental purpose of expressing the government's preference for childbirth over abortion. In that respect, it's substantially similar to what the court or the government was doing in Rust v. Sullivan, in which it facilitated discussion by private doctors of the government's message on abortion.
In this case, is it a significant difference that the amount of the expenditure depends simply on the private expressions by private individuals who choose to buy those license plates?
The fact that private individuals, Justice Moore, are the conveyors of the message is consistent with what this court detected in Woolley. In Woolley, the court recognized the fact that although there was a private individual that was carrying around the government's license plate message on their car, the message was governmental, and that it was legitimate for the government to pursue avenues of expression of its own message. What the court took issue with in Woolley was their compelling a private individual to aid in transmitting that message. However, the court recognized that the message on the license plate was an official view and was the state's ideological message.
Is there any limit in your position as to what the state's message could be that it could allow its residents to choose to put on their vehicles?
Well, Your Honor, the only limit would be what private individuals would be willing to put on their cars.
A thought that's come to my mind is, suppose the legislature of Ames decided that it would endorse a vote Republican label, and only vote Republican because the state of Ames is majority Republican at the moment. Would that be permissible under the First Amendment?
That's obviously a tough question, Your Honor, because it's a very controversial issue, but of
You really
course,
think that's a tough question?
Yes, but I'll try to answer it. This court has actually acknowledged that the government needs to be able to speak on controversial as well as non-controversial issues. And in some people's mind, taking a stance on abortion is more controversial than taking a stance on whether to vote Republican or Democrat. So yes, I can't think right now off the top of my head of any reason why they couldn't put a political message of that nature on a license plate.
Well,
And not offer a vote Democratic.
Right.
And that doesn't bother you?
Your Honor, the reason that that doesn't bother me is because there are significant alternative channels for private expression. Private individuals can express their own messages on their own cars if they so choose by getting bumper stickers that say whatever it is that the state's not saying that they want them to say. The only real qualm that, or the only real problem that Ms. Jones has with Ames's statute is that the government is not putting their imprimatur on an expression of support for a pro-choice viewpoint. Ms. Jones has not contested that she is able to express her pro-choice viewpoint in a variety of other ways, but the fact that she can't get a license plate that says pro-choice just means that the government hasn't put their own stamp, hasn't put the name of Ames on a license plate with her message.
If I follow up Judge Moore's question, though, doesn't it seem to you that if individuals, private people, are paying the extra money to have this message, doesn't that tip the balance over to the idea that this is a private speech? It's not the government speech. If it was the government's policy and the government speech, they could pay for that. If people wanted to have that, they could just pay for it. But here, private people are making the decision as to whether they're going to have what kind of plate they want, and then only those that want to advance a particular idea or point of view are allowed to spend their money, and only on that, kind of like the Valero situation, where you're limiting how much money people can spend, or how much is available for people. In other words, people can't spend money advancing this on this forum that the state has established.
Well, Your Honor, the Choose Life License Plate Act does not in any way limit the ability of individuals to contribute to the political causes and to the funds of their choice. It just doesn't facilitate through the government individuals contributing to certain funds. In this respect, it's no different than those boxes you sometimes see on your tax returns which say, you know, check this if you want to donate a portion of your tax return to a specific cause. Private individuals through their own channels can contribute to whatever they want. But moreover, the funding question is funding of speech is not really any different from what you see in other contexts in which individuals volunteer to help the government convey its message.
Well, in using your example, could the government put on the tax return either simply give $1 if you wish to choose life without making an alternative choice to choose choice?
I believe that the government could make available opportunities, as it currently does, for individuals to fund certain messages and not make available opportunities for them to fund alternative messages that they could support through other means.
Do you have any cases that you would rely on for that principle?
Well, it's very similar to the situation in Rust v. Sullivan, in which the government enlisted private individuals, enlisted private doctors to disseminate the state's message. But moreover, there are common practices. For example, the government commonly runs anti-drug programs for school children, things like the DARE program, in which the government may invite private individuals, parents, for example, into the classroom to help the state to convey its anti-drug message to students. But no one would argue that the government need to make open floor time also to parents who want to express a pro-drug message.
The Timothy O'Leary Society would lose that case.
I'm sorry?
You made too young for that. He was a professor at Harvard who suggested that we tune in and tune out, something like that? Drop in, tune in, tune out. To take LSD.
Well, I'm not convinced that that professor would want that message delivered in his or her child's classroom. But
well, he wouldn't like the idea that drugs are good.
Well, I mean, that's not such a crazy case, right? I mean, it's just it hasn't been brought because it's not a popular cause. There isn't a close division of opinion on that, but that's not dispositive of the relevance of the question, right? What would happen?
I think that what would happen was that this court would reaffirm the principle that it's repeatedly acknowledged. It stated explicitly in Rosenberger that the government may enlist private individuals to assist in transmitting the government's message. And I think that this serves a variety of logical purposes. First of all, it just makes the government's speech more cost effective. But moreover, this debate has been framed in such a way that it seems like the government's speech interests are always at odds with private speech interests and that they can't kind of be compatible. But in reality, if democracy is functioning well and if people are satisfied with their government, they will, or many people will want to endorse the government's message to express their support for their government, and people who don't want to endorse those messages have recourse with the political process to vote in different officials who will take different stances on issues.
So the incumbents of the moment, though, are able to conscript this forum for advancing purposes that may help them retain power. Right? Not because they're popular, but because of the propaganda. The vote Republican license plate or any number of other things that they think will help their reelection prospects.
Well, Your Honor, this goes to the issue that Justice Scalia raised in his opinion when he was a district judge in Block v. Meese, in which he stated that it would be a mistake to assume that speakers are really so fragile and scared of the government and that their ideas are so fragile and subject to government suppression that if the government takes a stand on something, and if it takes a stand on something controversial, it really impairs the ability of private individuals to get their message out there. I just don't think that that's the case. But moreover, I think that the idea that there's a substantial...
Well, you're suggesting that there's a parity, an equivalence between a state-issued license plate that says choose life and a bumper sticker on the next car that says pro-choice?
Again, Your Honor, I think that the only difference between those two means of speaking is that one bears the imprimatur of the state, clearly. It's a license plate that's been issued by the state with the state's name on it, and so people are able, by that, to know what their government stands for, to know that their government has a stance on abortion. And the pro-choice message is expressed equally effectively if it appears in the same region of an individual's car, but it doesn't bear the imprimatur of the state because it's not the state's message. Moreover, petitioners make this whole issue about whether there is a substantial component of private speech present, but in fact, finding a substantial component of private speech is not determinative of whether that speech is occurring within a forum. In this case, there is a private expressive interest, but the private expressive interest is occurring outside of a forum. It exists only because the government has made available the ability for private individuals to endorse what their government stands for.
So what's the forum you're talking about then?
I'm sorry, I didn't mean to say that it occurs outside of a specific forum because we haven't identified any forum here, only to say that it doesn't occur within any speech forum at all. This instead is government speech, which is evidenced by the fact that the government has made it possible the speech for a governmental purpose to facilitate the government's message of choosing childbirth over abortion. And additionally, and perhaps most importantly, because the government possesses editorial control over the form and content of the message that's being expressed here. Petitioner advances...
Doesn't the driver express editorial control over whether or not to display the message?
Your Honor, it's true that the driver does have a choice whether to display any specialty license plate or whether to display a particular specialty license plate, but that is only, that's only distinguishing this case from a case like Woolley in which the display of a particular license plate was compelled. It doesn't change the fact that editorial control, in the sense that this court found to be relevant in Southworth and in Rosenberger, is the ability to determine the form and content of messages that are delivered. This court specifically acknowledged in Southworth that the ability of students and the fact that only the students really gave form and content to the messages that were being expressed through student publications and student organizations meant that the speech there was the students, because the students possessed editorial control over that speech.
What about Santa Fe?
In Santa Fe, the speech was also found to be the government's because the government specified parameters and pretty specific guidelines about what the speech could entail. And although there the government didn't write the specific message that the students would be delivered, the message was subject to the approval of the government. And in fact, the scheme there was substantially similar to the one here in that the government made available the option to students of electing a speaker or having no speaker at all. And once they determined to have a speaker, they could then determine the particular speaker that they wanted, and that speaker could craft a message within the guidelines established by the government. That operates much like the license plate scheme in that the government makes available to private individuals the option of having a specialty license plate or not having one, and if the individual elects to have a specialty license plate, they then have a choice from a range of license plates prescribed by the government. For this reason,
in each case, the particular license plate that's allowed is with a particular government message. Is that correct?
yes, Justice Moore, that's correct.
So what your opponent has argued that a different test than your four-component test should be the appropriate test. Do you have any particular problems with that test that your opponent's arguing for?
Yes, Your Honor, two problems. First is the determination whether there's government speech relies on a novel application of Texas v. Johnson, a case that's never been found or never been even applied to distinguishing private from governmental speech. But more significantly, petitioner's test relies on a finding whether there's a substantial private expressive element.
What doesn't that recognize that there's a continuum, that there's government speech, private speech, and then there's an area where there's both kinds of speech?
Well, Your Honor, essentially there has to be a binary determination made between whether there will be a viewpoint neutrality requirement imposed or not. But there's not this kind of binary difference between government and private speech in the sense that you really need to analyze different characteristics of the speech to determine who is speaking. But to say that finding a substantial private expressive element would be determinative has a variety of problems. First, it would essentially reverse the outcome in Rust v. Sullivan, a case in which individuals were speaking for the government, and the patients in that case, there's no evidence that they were able to distinguish that it was the government's message they were hearing. They were talking to their doctors. Their doctors had substantial control over the particulars of the message that they were transmitting, yet this court found that that was government speech.
Could that be distinguished on the basis of funding?
I don't believe in subsequent discussions of Rust v. Sullivan, this court has ever held that funding was really the fundamental aspect there. But there's more support for that principle to be found in Santa Fe, in which, again, it was found to be the government that was speaking, in spite of the fact that there was a private individual that was actually delivering the message and had some control over the specifics of what message would be delivered. Again, I don't think that anyone could deny that there was a substantial private expressive element going on there, but nonetheless, it was found to be government speech. So I think that the implications of petitioner's test would be somewhat radical.
You have done a pretty good argument, made a good case, I think, of poo-pooing the idea that because there's a component of private speech, that therefore we always treat it as private speech. The opposite, though, is what you seem to be espousing, is that if there is a component of government speech, then we treat it all as government speech. What is your test? For instance, if we had a case where the private speech aspects outweighed the government speech aspects, how would we decide that as a court? How do we get into this, playing government and balance of power situation, deciding this mixed component question?
Justice Benevides, that's why I believe that our test is particularly apt here, because our test involves analyzing whether there's an element of private or government editorial control over the speech, whether the speech serves a governmental or private purpose, who is the literal speaker of the speech, and who bears ultimate responsibility for it.
If it's we as the government and we as the majority, and we passes the law, isn't all this policy decision that made by the state, isn't that an individual? Wouldn't that argue that this is really private speech? The legislators who are elected are reflecting the will of the people, and the people are all individual people.
Well, Your Honor, it's true.
And they can count. Legislators can count.
It's certainly true that private and governmental speech aren't perfectly separable, because yes, the government is made up of individual citizens of our country. However, the fact that the government operates in its governmental capacity to formulate messages that are the government's and to enlist private individuals to transmit those messages is something that this court has acknowledged to be legitimate. In Rosenberger, it acknowledged that again in Velasquez, and it has recognized that implicitly in in Woolley and in Barnett.
Is there a component of how minor the speech is? This court has a long history of looking at the disadvantaged and the minority and protecting them from the will of the majority. Now, it would seem that under your scenario, the more an idea is entrenched, the more it can be espoused by the state, and the more a person is in the minority, the more hurdles that can be put in his path or her path by way of labeling something government speech.
Your Honor, Ms. Jones has never claimed to be a discrete and insular minority in the sense that this court has found necessary to give extra protection, only that she has a political viewpoint that's not the viewpoint of the majority, and through the political process, she hasn't succeeded in electing legislators who support that particular point of view. So the fact that her viewpoint is not the viewpoint of the majority only means that she has recourse through the political process to try to elect officials who will espouse the viewpoints that she prefers. Thank you.
Questions? Thank you, Ms. Oya. The appellants have reserved 5 minutes.
Thank you. First, one brief point on standing. The court noted in Heckler v. Matthews that when the right invoked is that of equal treatment, the appropriate remedy is a mandate of equal treatment, a result that can be accomplished by withdrawal of benefits from the favored class, as well as by extension of benefits to the excluded class. That's all we're asking for here. It's simply not possible for Ms. Jones to ask this court to order the legislature to pass some new statute authorizing her pro-choice plate. If it were, then that's what she would be asking for, but it isn't. Now, on the First Amendment issue, everything about this program indicates that it's private speech. One of the most important things that several of your honors mentioned is the question of who's paying for this speech. And it's simply not true, as respondents contend, that this has not been a salient factor in this court's inquiry. In the Southworth case, for example, the court noted that if the challenged speech were financed by tuition dollars and the university was responsible for its content, then the case, as the court put it, might be evaluated on the premise that the government is the speaker. But that is not the case before us. Here, the private individuals pay for the speech in question. In addition, under most of the specialty plates, no plate is produced until at least 300 citizens have signed up for the plate. Again, this depends entirely on private action.
What's the significance of the 300 then?
The number 300 isn't any magic number. It simply indicates.
But what's the point you're making about the fact that there's a minimum requirement?
The minimum suggests that the program as a whole depends on private action. Nothing gets communicated under the program until private citizens choose to make that happen.
Well, the state says we'll put out this message if there are enough people who were interested, right?
That's true, but if the state were intending to convey its own message, it seems that it would be an odd way to do it to require a minimum number of citizens to sign up for the plate.
Well, let's just say,
universities do that with classes? If 15 students still enrolled, you don't have a class?
In any case, many other aspects of the program, indeed all aspects of the program, suggest that it's private speech.
Speech just says that speech has its price, right? The
Indeed.
state's not willing to pay more than a certain amount if it doesn't have, at least as with the case of the classroom. That's
no doubt true, but again, the point is that the private speakers are the ones ultimately paying for the speech. Some of the license plates indeed feature messages. For example, the animal rights plate features the words, "I care." Now, it's impossible to read the words "I care" as expressing anything other than a message that the person who owns the car and has paid for the plate cares. Grammatically, I mean, the "I" in that phrase cannot be taken to refer to the government.
So does there have to be an "I don't care" plate?
That would be an entirely different case, Your Honor. And that actually brings up an important point.
Don't you have to agree that there would have to be?
Not necessarily, and I would like to address in the same vein Justice Benevides' earlier question about whether if the state has anti-fascist plates, it's also going to have pro-fascist plates. And the answer is not necessarily. The state is certainly free to engage in content-based exclusions from the forum. So it could exclude, for example, the topic of abortion altogether. It can also even engage, if the court deems this to be a non-public forum, it can also engage in status-based exclusions. So in Forbes, for example, it was all right for the television station to exclude a candidate from the forum because he had no viable chance of being elected. Now, that inevitably turns to some extent on the candidate's popularity. Nevertheless, that would be acceptable, even under our analysis. So
But under your analysis, if there's a controversial topic, doesn't the state have to allow both sides of that controversy? So gun control, yes, gun control, no gun control.
Yes, where the state sets up a forum for private speech.
And does it have to be reduced to slogans, or can there be more subtle variations introduced so that there might be more than two positions?
Well, there might be more than two positions, and the most reasonable thing for the state to do is thus to adapt some sort of application process, as every other legislature in a reported case to run a program like this has done. When there's an application process, the legislature can have a minimum number of people who have to sign up for a plate before it's produced. And that's an entirely content or viewpoint neutral restriction. We have no objection to that.
Could the legislature do that and still proclaim a preference?
If the legislature established viewpoint neutral regulations and, for example, only a certain group could meet the minimum, and it didn't appear to this court that the government was merely manipulating its facially neutral regulations so as to suppress speech, then that would be perfectly fine.
So the government, you're saying, has to set up an application process on a neutral basis so that it accepts, if there are enough minimum to meet the minimum, it accepts the obligation to then create a plate that says something that is contrary to government policy.
Well, seeing that my time is up, I'll merely note that, of course, the government is free to engage in content-based exclusions. It can exclude any topic that it wants from the forum entirely. But once it allows
Right. Well, now down here in Washington, there are a lot of people who are interested in saving the Chesapeake Bay, and it is, in fact, the policy of all of the surrounding states and of the federal government to spend hundreds of millions of dollars to try to do that. And one sees Save the Bay stickers all over the place. So if Save the Bay were a license plate slogan, the people who didn't think that was a good investment would also be able to get a license plate saying, the heck with the Bay.
Yes, Your Honor, but only where the state has set up the program so that private speakers convey their message. The state, for example, if it wanted to assign license plates randomly or to have multiple license plates that rotated on a yearly basis, it could convey as many messages on its license plates as it wanted, as long as it doesn't operate that program.
I'm not sure about that after Woolley.
Oh, it couldn't compel the citizens to bear the message. Woolley was clear on that. But just as many states don't have specialty license plate programs at all, they simply have a state motto. The state could change its motto from time to time. And there's certainly many other avenues by which the state can communicate its message.
This is a matter of real interest here in Washington because the District of Columbia has just started this year putting out license plates that say taxation without representation, which some people think is a good idea.
Indeed, Your Honor. It doesn't, as far as I know, the state doesn't allow citizens to choose whether or not to have that message, does it?
No, you can
in any
opt,
case,
I
I
think
see
you
my
can
time
opt
is
out, but thank you, Mr. Monson.
Thank you.
Mr. Kellner, thank you. Mr. Katz, Ms. Oyer, thank you all. The case is submitted. The court will take a brief recess. The court's been asked to render an unusual form of judgment in this case, not to opine on the merits, that is to say whether whether the appellant has standing, and whether the statute is unconstitutional, but rather to judge the advocates themselves, something that we do every day but don't ordinarily announce. So it's a pleasure to read this judgment, starting with the best oralist. I know there'll be differences of opinion in the room, but somebody has to decide. And it's the view of the panel. All of these judgments are unanimous. I'm really dragging this out. That the best oralist moniker goes to Ms. Oyer. The award for the best brief, which is made vexed by the fact that there are 3 briefs, that is to say the petitioners filed both an opening brief and a reply brief. We're not really choosing the best brief, we're going to choose the best briefing. That will go to the petitioners, appellants. Now, somebody has to win as well overall, and that decision is made particularly difficult by the fact that the teams were so well matched. Not surprising, having each survived several rounds of competition, as I understand. The team that is best overall is judged on both the oral performance of both of the advocates and on the brief, which was the product of the entire team, and was our judgment that the overall better team is the respondents, the Katz and Oyer team. To be more precise, it was the John Rawls Memorial Team. We're each going to be brief in commenting on the proceedings this evening, and then we're looking forward to meeting with the team members to discuss the overall competition briefly after this session and before the reception. I want to just say from my part that you all turned in excellent performances, both written and oral. I do think that on the oral arguments, that it is something that you come to realize with with time and experience, that it's really a conversation you want to have with the bench, as though you were sitting around the table and discussing something. It's obviously more formal than that, but there's got to be, it can't be programmed. There's got to be give and take and responsive to what the court's interested in. It's sometimes the wise course to abandon a topic and move on to something else. In any event, to try to be as responsive as possible to the questions. In each of the presentations today, or all 4 of the presentations, I would say, there were areas in which people were very good, others in which they could have done better. I can only suggest that in addition to the great training that you've acquired by going through this competition, that you take the opportunity while you're here in Boston this year, or wherever you'll be for the summer, or if you're being graduated, where you'll be working next, just to go down to the courthouse from time to time and see some of the arguments. If you know when there's a good one coming up, so much the better. The best argument I have ever seen, bar none, was an argument that Professor Tribe put on in the Supreme Court, which I went up to see because I had a dog in that race when I was in the government. But it was just as if he'd had 9 people over to discuss something, and they were discussing. The give and take was really impressive. Well, they're not all that good, but you will see mistakes. You'll see things that you want to emulate if you do observe arguments from time to time and incorporate that into your repertoire.
I want to second what Judge Ginsburg said about how impressed I was about the advocacy skills that each of you showed in the briefing. The briefs were first rate. I think all of the briefs were really at a level that's way beyond what most of the briefs that we get in the courts of appeals throughout the country are. And I think your oral argument also was outstanding. I think one of the things that's hard to understand is that you can get friendly questions from a judge, and you want to make use of friendly questions, and you can get tough questions from a judge who's going to end up deciding in your favor. So you really don't know what's happening at oral argument. What you do need to do is what you did, which is to make the best use of the questions that you can and keep getting the material that you feel is critical to your winning, whatever the 3 or 4 points are for your side, to keep going back to those and to emphasize those and to weave the questions in. But I agree completely with Judge Ginsburg that it is a dialogue, that the judges are asking questions usually because they have concerns and issues that they feel they need to resolve in order to decide how to decide the case. And I think that your oral arguments really helped us to understand the issues in this case, and if it were a real case, we would have benefited a lot from this experience here. And who knows whether someday one or another of us will have one of these cases. But I'm very much impressed by the caliber of the briefing and of the oral argument, and certainly you would be welcome in the Sixth Circuit as advocates. You would raise the level substantially.
I would like to echo the comment about going down to the courthouse and listening to some arguments. There is a remote possibility that all of you will be handling constitutional issues. And very few of you will probably go into actual litigation and arguing cases. But for those of you that do and are interested in it, you need to get down to the courthouse. There's a lot of day-to-day things that are going on. You can keep up with who's coming to town and who's arguing. I've had the good fortune of having several of the faculty members argue to me on different panels that I've been on, and I've heard some of the great lawyers in this country, in the civil and criminal area, and you always learn. We'll have a little time for the individuals to talk about little pointers and individual things, so I'll just talk about things in general. And what I like to get across on these moot court arguments is the idea that our whole system is based on advocacy system. In other words, we've bought off into and espouse and cherish the idea that truth and a good system of law is going to come about because we have lawyers on both sides of an issue presenting the best arguments to judges, and that as a result of being well informed, the judges are going to make decisions that are going to bind other people in similar situations. And at the very core of our system is a reliance and a trust and a faith in the work of lawyers. I don't tell a whole lot of lawyer jokes because I really love lawyers, and I think that, you know, we were writing the Magna Carta when doctors were putting leeches on people. You know? this is a wonderful, wonderful profession with tremendous responsibility to the members of your community, the people in your country. And in the United States of America, the greatest country in the world, is a symbol to all the other countries in the world. And a lot of that goes back, and how good we are and how good our system is, goes back to y'all. And the people that were in the halls before you and the other law schools around this country. And it's really easy to get worked up when you're going to get an award for being the best oralist. But you know, you may be arguing for an immigrant, a Social Security recipient, criminal case for the prosecution or for the defendant. And that's all part of the positive law, becomes a positive law of this country. And so it's not to be taken lightly, your duties. Just keeping, I would ask you to always be as serious as you were. You may not have the time, but always be as serious and be as mindful of how important you are to our society and how important you are to the judges. We don't. The lawyers shape the law. We're referees. We decide whether the basket is good or somebody got in the end zone. But you run with the ball within the parameters that we set. And you shape the issues and you inform us. And we need you to be good and we need you to do good work. And our society and our community needs that. So I congratulate you on choosing this law school and to be a choice to become lawyers. Thank you. God bless you.